talk about estate planning, and hopefully, for those of you who have been here before, can pick up some new information. And for those of you who haven't, this information will be really, really good for you. Craig Ansel is our legal counsel. He's been with the board, or worked for the board for several years now. So we really do appreciate him coming out here and giving us a short spill. We have a few presenters, but lunch is expected at 12, so if you guys will just bear with us, we'll get through, and then I'll be able to get you some happy turkeys. Thank you. Craig?
Thank you, Gracie. Thank you, everybody. It's always a good opportunity to come out and see everybody at one of the pre-retirement seminars, because I think it's a good opportunity to focus on some things that we don't always focus on. Really uplifting things like death and taxes and things like that, things we really like to hear about. So I always like to give you the bottom line before the presentation, some things that you can take home with you. If you don't get anything else out of today's presentation, I want you to take this to heart. I'll call this 5 rules to take home with you. Rule number 1, never argue with an idiot. They drag you down to their level, and then they beat you with their experience. Rule number 2, never give yourself a haircut after 3 margaritas. Rule number 3, a clear conscience is usually the sign of a bad memory. Rule number 4, normally you gain experience right after you need it. And rule number 5, this is my favorite, 99% of the lawyers give the rest of us a bad name. So, with that in mind, let's talk about some things that might be important or could become important for you or for other firefighters that you know. I'm really going to spend my time today on 2 totally different topics, but they're topics that really become important depending on your circumstances. And the handout covers both of those, and so we're going to go through those in order. The first part of the talk is on qualified domestic relations orders. The second part of the talk is on estate planning and will preparation. So we'll do qualified domestic relations orders first. Now, for those of you who are not married, take a break. You don't need to listen to this. For those of you who are married and are never going to get a divorce, you don't have to listen to this. For those of you who are married and are thinking about a divorce, better pay attention. And if you're a spouse in here, pay attention anyway, because it doesn't matter what the firefighter says, there's always a possibility. No, I think it's important to think through this because of the significance that it has for the retirement system. Let me give you some basic overview, and then we'll talk about the specifics. Federal law and state law say that a firefighter's pension can only be paid under the terms of the plan. It can't be diverted to somebody else unless, the unless is what criteria have to take place. What that means is the firefighter earns a pension by working in the retirement system over a number of years. If that firefighter gets a divorce and he or she was married during the time that that pension was earned, Texas law typically says that some or maybe all of that pension is to be divided between the former spouses, depending on when the work was made, when the pension was earned, how long that they worked, and all that sort of thing. But the big picture there is, in the case of a divorce, it is fairly likely that a firefighter and his former spouse or her former spouse will be dividing that pension in some form or fashion. Doesn't have to be. So start with this rule. Number 1, it's whatever the parties agree to or the court orders is what controls about how the pension is going to be divided or not. But assuming that the parties agree or the court orders that part of the pension gets paid to the former spouse, then there are some hoops that you have to jump through to enable the retirement system to pay the benefit that way. And that's where the qualified domestic relations order comes in. Because of the way the law is written, it says the retirement system board cannot give a payment to a non-firefighter unless the court order satisfies a number of different requirements. And that's really the key to this. What's important for you to take away from this is not necessarily to know all the ins and outs of what has to be in here, but if you're going through a divorce or you know a firefighter that is going through a divorce, make sure they tell their attorney early on if that's going to be part of the divorce decree, if the division is going to be part of what's going on, to make sure that the divorce decree includes the right language, and, this is an important and in addition to the divorce decree, that a separate order called the Qualified Domestic Relations Order is signed, or at least prepared for signature, during the course of the divorce, not after the fact. So let's talk about some key terms in this area. First of all, what's a domestic relations order? Well, typically it's the divorce decree, but it can be more broad than that. It can be a court judgment, it can be a property settlement, it can be child support order, it can involve marital property rights, all sorts of different orders. Typically, though, where we see them with the retirement system is in a divorce decree. The second important term is alternate payee. That's the former spouse. The person who is not the firefighter who is claiming or entitled to a portion of the firefighter's pension. Alternate payee typically means former spouse, although not always. And then qualified domestic relations order, that is a domestic relations order that satisfies all of these different requirements in order for it to be qualified. So, who needs to be concerned about it? Well, every firefighter and spouse, and possibly children, if there is a division of benefits that's contemplated where the retirement benefits are going to be paid to somebody other than simply and entirely the firefighter. What's unique about it for our retirement system? Well, a couple things. First of all, the Corpus Christi Firefighters Retirement System is a defined benefit plan. Now, Sandra was talking to you about 457 plans. A 457 plan is a defined contribution type of a plan. Every firefighter has his or her own separate account in the 457 plan. The retirement system does not have individual accounts. All of the money that goes into the retirement system out of your paycheck as a firefighter or a contribution from the city goes into a pool. It goes into a defined benefit plan, which means that you don't have just a separate account when you leave, like the 457 plan, for example, or an IRA or a 401k, where the court could say, or the parties could agree, we're going to divide this amount that's in there as of the date of divorce 50-50 or 60-40 or 70-30 or whatever it is. Instead, what your retirement system provides is a benefit stream, a payment stream from the time that you become eligible for retirement until an event that terminates it, whatever that may be, your death or whatever happens. So in dividing those benefits, the retirement system has to have some very precise information to know exactly how to calculate how that benefit is going to be divided. For example, if you have a divorce decree that simply says the court awards half the retirement to the alternate payee, then we at the board level, and me as attorney for the board, have to ask some questions. At what point do we calculate that 1/2? And 1/2 of what? Is it 1/2 of the total benefit that the firefighter is entitled to receive? Well, what if the firefighter and the spouse were only married for the last 5 years, let's say, of his career or her career? Does that mean it's 50% of the part that was earned in the last 5 years, or is it 50% of the whole thing? So as a result of that, because of that need of the way your retirement system is structured, we have to take into account some special factors. The other thing about it is, if a firefighter and spouse get divorced and the firefighter is still employed, the firefighter's pension does not start as of the date of the divorce, obviously, because the firefighter's still employed, still working. So there's no benefit stream that starts getting paid out to the alternate payee, to the former spouse at the time of the divorce. That divorce may set in place the amount that's going to be paid, but the beginning date of that payment doesn't take place until the firefighter is entitled to start drawing benefits. So, for example, if you got divorced at age 40 and the retirement system says you can't start drawing benefits until 20 years and 54, then nobody's going to start drawing benefits. And that's often a subject of confusion because a lot of times attorneys are used to dealing with IRAs or 401ks where they say automatically segregate that defined contribution account right now. Now the alternate payee has a fund that's available to be drawn on. And as Sandra was saying, you know, you can get at money earlier than 59 and a half, but it just may trigger a penalty. So those are some important things for the firefighter and spouse, and really more importantly, their attorney to understand about what's unique about your retirement system. The third thing that's unique, and this is obvious, I guess, but it isn't always obvious to the attorneys that are dealing with them, the retirement system is a governmental plan. It is not a plan set up by private industry. And there are some different rules that apply to governmental plans with respect to quadros than apply in the case of a private company's plan. So understanding what that means is important for the firefighter and the spouse, but more importantly for their attorneys. So why do you have to have a qualified domestic relations order? Well, I alluded to that a minute ago. First of all, state and federal law limit what the board can allow to be paid out. There are certain hoops that have to be jumped through in order to make it work. And those are found in the Texas Government Code. And there's a citation to the part of that in your paper that you can show to an attorney if they're wanting to find out where those rules are found. But I think more importantly for our system, what the board has done for you over the years is develop a sample or suggested form of qualified domestic relations order that a firefighter or soon-to-be ex-spouse can give to their attorney to say, this is a format of an order that the retirement system has said, if it's properly completed, will satisfy not only the state and federal rules, but also the unique aspects of our retirement system so that it can pass muster, be approved, and then provide for the division of benefits. How is that process done? Well, it works something like this. A firefighter calls the office, or a spouse, soon-to-be ex-spouse, calls the office and says, we're going through a divorce. What do I need to do? And Mary or Gracie can provide you with this sample form of qualified domestic relations order. What does it do? Number one, let's talk about what it doesn't do, because that's the most important thing. What it doesn't do is it does not say how the firefighter's benefits are going to be divided. The board has nothing to do with that. That is not a decision the retirement system makes. That decision is made by the parties, the husband and wife, or it's part of the court order. All the retirement system does is implement that decision in a way that fits our retirement system. So, for example, if, and this is not required, but it's fairly common, if the court or the parties look at this and say, okay, firefighter worked from beginning date to date of divorce, and in that period of time, the firefighter accrued a certain amount of benefit. Okay, as of the date of divorce, we can calculate out what your benefit would be if you retired on that date. Now, you may not be eligible for retirement on that date, so in that case, we calculate out a hypothetical benefit as if somebody had worked the full 20 years. But we can calculate out, as of that date, the amount of benefit that the firefighter would have earned. Now, if the firefighter and that spouse were married during that entire period of work, then that pension benefit that's earned during that period of time is community property. If the firefighter and spouse were only married for part of that time that the firefighter worked, then only part of that benefit that is earned or accrued as of the date of divorce is community property, and the rest of it that was earned before marriage, in theory, is the separate property of the firefighter. Now, ultimately, that's a decision that the divorce court has to make, or the parties have to agree to. But whatever the agreement is, we're looking at that pension benefit that's accrued up through date of divorce, and we're going to say how much of that is allocated to each person. If it's all community property, if husband and wife were married during the entire time of the firefighter's service, and it's all community property, then typically, doesn't have to be, but typically, the court says, or the parties agree, we'll split that 50-50. So what the qualified domestic relations order does is it says, we're going to measure that benefit under the plan document that's in effect on the date of divorce. Whatever the plan says the benefit is on the divorce date, that's what controls. And it measures, and it says, if the firefighter retired at that date, or died, or became disabled, whatever triggered the benefit, we're going to figure out how much, in a dollar amount per month, that firefighter would be entitled to receive. And then that percentage that's applied by the court or by the parties is applied to that dollar amount. So it actually calculates out and says in the order, this much of the monthly benefit, this dollar amount of the monthly benefit is going to be paid to the alternate payee whenever the firefighter first becomes eligible to receive benefits. So what that really says is it locks in or fixes the portion of the benefit that the alternate payee, the ex-spouse, receives, and it says the rest of the benefit goes to the firefighter, because the firefighter may work a number of more years and earn additional benefits. Well, if he or she is not married to that ex-spouse anymore, the ex-spouse doesn't normally get a claim to that additional benefit. So the form is structured to measure, as of that date of divorce, how much is payable to the alternate payee. Well, what else is unique about your retirement system? You have the opportunity for a retro drop. Well, think about that. The way the retro drop works is it says you worked up to a point in your career and you retire. But the retro drop says we're going to treat it as though you retired some earlier period, whether it's going back a year, 2 years, 3 years. You retro back and say, I'm treating it as though I left back there, and I'm getting a lump sum that's calculated based on that time period that you retro drop back. Okay, so now we have to have in your quadro something that says, if the firefighter elects a retro drop and gets a lump sum, how much of that lump sum goes to the alternate payee and how much of that goes to the firefighter? And again, it's up to the parties. It's not the retirement system. We just have to have something in the document that says to the board, if the firefighter retires or becomes disabled and elects a retro drop, how much of that lump sum goes to the former spouse? Because otherwise the board doesn't know how to pay that out. So those are the things that are unique about the system's retirement plan and the things that need to go in there. Now that issue of the retro drop has raised some interesting theoretical questions, and they're not so theoretical when you start talking about it in terms of your real money. But suppose you got divorced as a firefighter and then you worked for 10 more years, and then you did a retro drop. Well, that retro drop period is entirely while you were no longer married to the person that's the alternate payee. You may have remarried, you may have stayed single, it doesn't matter, but the former spouse was not was not married to you during that retro drop period. So should the former spouse be entitled to part of that retro drop period, retro drop payment? Well, if you're the firefighter, the answer is pretty obvious. If you're the alternate payee, the answer is equally obvious, but it's just different. The argument is something like this. You are not eligible for a retro drop lump sum unless you work an entire career to become eligible to retire. So if you were married during that period of time, while you were earning the full retirement and earning the ability or the right to a retro drop payment, then the former spouse has a community property right because he or she was married to you during the period of time that you were earning that benefit. Therefore, they're entitled to something. Okay? Now, you can argue about that all you want to. It's not up to me to tell you whether you're right or not. That's the judge and the party's decision. But I'm telling you that that issue is out there. So if you're the firefighter, that issue is going to be on the table to decide. What our form does, the recommended or suggested form for the retirement system, gives you choices. It says you can put in there a specific dollar amount. When I retire and I draw a retro drop lump sum, my former spouse is going to get X dollars, $500, $1,000, $20,000. Or it can say my former spouse gets X percent, 10%, 20%, 50% of the lump sum. Or, and this is what I think is the logical one, but it's not up to me to decide, my former spouse is going to get a percentage of the lump sum that is equal to the same percentage that is calculated for a monthly payment based on the period of time that we were married compared to the period of time that I worked. So if, for example, if we were married 5 years out of the 20-year accrual period and I retire with exactly 20 years, then we were married for 1/4 of the time that I accrued that benefit. So my spouse would be entitled, theoretically, to 1/4 of that total pension. So we calculate out the pension and say, okay, if we're going to divide that up, what part of it's going to go to my former spouse? It comes out to a percentage. Okay, you could argue, and I think this makes sense, that that percentage of the lump sum portion of the retro drop, as well as that percentage of the monthly payment, the reduced monthly payments, if you elect a retro drop, goes to the spouse. It's not up to me to decide. It's not up to the board to decide. It's just something that needs to be decided as part of the order so that we can know how that's going to be dealt with. So how does the process work? If you are going, or somebody else is going through a divorce, remind them or remind your attorney that that order needs to be prepared and presented to the board before it's finalized by the court. It gives us a lot more leeway if we can say, look, you need to tweak this, you need to change that. Before the judge signs it, it'll save you legal fees and running around. But the process works, you get the order prepared, and sometimes we get it when it's already been signed by the judge, and that's okay. Take it to the office sends it to me to review. I either say, yes, I recommend the board approves it, or I recommend that these changes be made. Then I'll send it back to the lawyer and say, here are the things that we recommend, dealing with form, not as to substance, not as to amount. Eventually, and I think almost all of them have been eventually worked out, we get the thing finalized, it comes back to the board at one of the regular monthly meetings, it's approved, and then it goes into the firefighter's file. If the firefighter's already retired, we start splitting the benefit payments. If the firefighter's not retired yet, it just sits in the file until the firefighter retires, and the benefits start paying out. Okay? So that's how the process is worded. And I guess what I would say in closing on that is, when do you need to start thinking about a quadro? When do you need to start preparing for it? Well, the earlier the better, because typically that's something that, at least I think, ought to be negotiated as part of the divorce settlement, because it doesn't need to be necessarily a split of benefits. It can provide, for example, that all of the benefits will be paid to the firefighter, nothing to the former spouse, but the former spouse gets some other asset out of the marital property. So it can be divided in any number of ways. You can say, well, the former spouse will get the first X number of dollars, or we'll split the first X number of dollars 50-50, and then the former spouse stops drawing benefits. It can be structured however you want it, but typically the attorneys for the former spouse say, no, I want it to be on a percentage basis. So that's the first part of this talk. That's the part about qualified domestic relations order. So before I jump off that topic into estate planning, are there any questions? Anybody have any ideas about that? Okay, so we'll jump off of that now, and we're going to talk about wills, trusts, and estate planning. Now, what I typically do in these talks is ask everybody to put their head down on their desk and close their eyes so that I can ask these questions and nobody will know how the answers are going to be read. I'm not going to ask you to do that because you don't have to answer these questions, but I want you to think about this. And you don't have to hold up your hand. How many of you have a will? Okay. How many of you know where it is? Okay. How many of you have read it in the last year? Okay. How many of you think you know where it is and kind of sort of remember what it said, but not real sure? And now here's the tough one. How many of you have the same assets, the same family situation, and the same desire for distributing your property as you did when the will was written? I would bet that unless you've done the will within the last 3 or 4 years, there's probably some change in your circumstances that might need to be looked at if your will has been done longer ago than that. And I will tell you that I have clients sometimes that come into my office that say, yeah, we've got a will. We did it in 1967, right after we were married, when we had 2 little kids who are now grown up and have kids of their own. And I say, okay, it's probably about time we revisited that to see what kinds of things we might want to update on that. Why do you need a will? Well, my view of that is it really falls into 4 different categories. The most obvious of which is who gets your stuff? Who's going to get your property? How do you want it divided up? You can say, under Texas law, anything you want to, virtually, about who gets your property. But if you don't say in a will who gets your property, then the state of Texas has, in its infinite wisdom, already decided who's going to get your property. And it may or may not be who you want to get your property. So that's the first thing, who gets my property. The second one, probably not applicable for most of you, but it could be, and that is if you have minor children, who gets your children? Or, as I like to say, thinking about my own children, who has to take your kids? That only applies with minor kids, but in some cases it can be important. The third one, I think, is probably the more insidious of these, but it can be really important, and that is who gets your hassles? Who gets to clean up the mess you leave behind? And trust me, you will leave a mess behind. And fourthly, who gets to pay your tax bill? Now that's a line in here that was a lot more important a number of years ago, but thanks to changes in the federal law, a lot of us don't have to worry about that anymore. But we'll talk about that in a little bit. So, who gets your property? Well, normally, and this is dangerous to say, but I'm going to say it anyway. Normally, if you're married, a lot, if not all of your property is going to go to your surviving spouse. That's typically what we see with wills. And a lot of times, that will is going to say, I leave everything outright to my spouse if my spouse survives me, but if not, I leave it to my children, typically in equal shares. Very simple, call it a sweetheart will, and it works fine. But the question that I'll ask you is this. If you're married, is it your expectation that if you die first and you give all your property to your spouse, that your spouse will then give it to their new spouse that they remarry after you're dead? Because they will. It won't go to your kids. Well, that's not true. It can in some cases. But a lot of times, if you have a sweetheart will, I leave everything to my spouse, you have to be comfortable with the fact that your spouse has the authority and ability to do whatever he or she wants to with that property after you're dead. And with the amount of marriages, divorces, remarriages, his, hers, ours, theirs, blended family situations that we have in the world today, it doesn't take a rocket scientist to figure out that it's a pretty good bet that if your expectation is that your property that you leave behind is all going to go to your children after your spouse dies, I can pretty well predict that out of this room, 2/3 of you, that isn't going to happen. Just because the way I see it happening. Now, I'm going to be really sexist when I say this, and don't take offense, this is just an observation. Moms are a lot more protective of their kids than dads are. Or another way of looking at that is, if the wife dies first and gives everything to the father, to the husband, he's going to remarry, he's going to give it all to his new wife. Okay? It just happens that way. If the husband dies first and gives everything to the wife, and the wife still likes the kids, more likely than not, she's going to give some of it, maybe all of it, to her kids and not all to the new husband that she remarries, or the boyfriend, or whatever. That's not intended to be sexist, it's just the way, it's what I see. That's what happens. So what do you do about that? Well, one thing you can do about that is you can say, look, I want to take care of my spouse. My goal is I want the property that I leave behind to take care of my spouse if I'm married. But if there's something left after my spouse dies, I want to be the one who says where it goes, not my spouse. My spouse can do whatever they want to with their property, but with mine, I want it to go to my kids or wherever you want it to go. So what you can do is you can write a will that says, I take my property and I put it in trust for my wife's lifetime. During my wife's lifetime, she can draw on that for the benefits that I specify, whatever it is I say she can get out of it. And she can use it all up if she needs to. But if she doesn't use it all up, if there's something left at her death, then the trust terminates and it goes where I say it goes, to my kids or wherever. Okay? What if you're single? What if you don't have a spouse? Well, if you have kids, do you want to give the property outright to the kids at your death? Or maybe another way to look at that is, how well will they deal with it if they get all of your money, property, assets put in their lap at one time? Are they going to be responsible with it? Are they going to be capable of managing it? Will they do a careful job? And I will tell you, based on my experience, that frequently when young people, and I'm not going to define where that blank gets cut off, but young people who don't have much life experience, who get a large amount of money dropped in their lap all at once, will tend to spend it. And they'll spend it quickly, and they won't do it thoughtfully. So if your will says, I leave everything to my spouse, or I leave everything to my children outright, understand that there's no more governor, there's no more control over how that's going to be dealt with. So again, you could say, I'm going to put property in trust for my kids, maybe until they reach a specified age. You know, it will stay in trust until they reach age 65 or some logical age like that. No, whatever, 30, 35, whatever you want. But the idea is, how do you manage that in a way that makes sense to you? And I think the way I would couch this is I would say there's no right or wrong in this. It really depends on what's right for you and your family. Some people want to have that dead hand control from the grave, holding on to everything as long as they can. Okay? We can do that. Other people say, you know what? I'm dead. I'm gone. I'm in a better place. I'm not worried about it. Whatever. That's fine. You can make that happen too. But the point is, you have to think about it. You have to decide what you want to have happen. So let's assume, for the sake of discussion, that you've got a will, and it really does say what you want as far as where the property is going to go, and you're pretty comfortable with that. So then I'm going to ask you, do you think that's the end of the discussion? And the answer, of course, is there's always an exception, right? If it was a lawyer talking, there's got to be an exception to every rule. There are properties, assets, that are not controlled by your will. And in fact, you can have stuff that's going places you never intended, and maybe you didn't even know about. What am I talking about? We call them non-probate assets. Assets that are controlled by something other than your will. Example, life insurance. Where does life insurance go? It goes to the beneficiary you designated on the form you filled out somewhere along the way, on a beneficiary designation. If your will says I leave everything to my 3 kids and the beneficiary designation says I give it to my one child, the beneficiary designation controls that life insurance. It all goes to the one child. It doesn't matter what the will says. So you have to look at the beneficiary designation. Same thing for your 457 plan. You're going to have a beneficiary designation for that. It's going to say who gets this money when I die. Well, do you want it to be the same as what your will says or different? Doesn't matter. Just know what it is as you do your planning. Maybe one that's a little less expected or less anticipated. How many of you have a bank account or a brokerage account that has your name and somebody else's name on it? Okay, maybe yours and a spouse, yours and a child, something like that. Okay. Do you know when you opened that account and filled out the signature card, did you check the box that says your name and the other person joint tenants with rights of survivorship? Joint tenants without rights of survivorship? Community property with rights of survivorship? Community property without rights of survivorship? Tenants in common? Maybe a convenience signer? If you don't know how you filled out that signature card, you don't know where that property is going. Because if it says your name and somebody else, joint tenants with rights of survivorship, for example, you die, it's all going to that other person. Now, if that happens to be the person that's benefiting under your will, fine, no problem. But what if your will says, I leave everything to my 3 children, and you set up the bank account because one of your children lives here, and the other 2 live in New Jersey and California, you put the one that's living here on the account to help pay bills and do business with you. And when you filled out that card, the new accounts clerk, who is typically not the most well-versed in estate planning in the community, says, oh, just initial this box, everybody always does. You may have just structured that account so everything in that account goes to the one child on the account rather than equally among the 3 kids that you pick. Or what if you say my spouse is on the account with me, but we put one of the children on to help pay bills and do business? Well, guess what? Instead of all of it going to your spouse, your half of it, if it's community property, is now going to be split in half. So your child is going to get a quarter of it, your spouse is going to get a quarter of it, and then the spouse keeps the other half. Point being, you have to know where those things are going to go if it's important. Now, if it's the household checking account and there's not that much in there, probably not a big deal. But if it's a large brokerage account, investment account, something like that, or 457 plan, you really need to coordinate that so that you know how those things are going to flow together. Now, I mentioned earlier that the tax part of this is really a lot less important than it used to be. And the reason for that is, for a person that dies in 2014, you can give away $5.34 million without paying estate tax. Okay, I'm out of here, that's me out. And for most people, that's true. Because if you think about it, that means a husband and wife between them can give away more than $10.5 million. For most of us, that's the end of the discussion. But for some people who have done well in their lives or inherited property or received a lot of property, it can be an issue. And all I'll say about it is that it's important to plan for that so that in the husband and wife situation, you can minimize or eliminate those taxes with careful planning. Last thing that I'm going to talk about is disability planning documents. Changing gears completely from the will. Disability planning documents are going to apply while you're alive, before the will ever comes into play. Because the will only applies at your death. But everybody in this room should have some basic disability planning documents. They're easy to get. You can get them on the internet. They don't cost anything. They're basically boilerplate documents. Number 1, statutory durable power of attorney. I give you the power to act for me if I can't act for myself. Doesn't necessarily mean I have to be disabled. Maybe I'm just out of town, out of state, out of the country. I give you the power to act for me. Number 1, it should be somebody that you trust implicitly. Don't ever give that power to somebody that you don't have complete faith and trust in, because they can steal you blind with it. But make sure if you've got somebody like that that you trust, that you have that. Because that person can see to it that your tax return gets filed, that your property gets managed, that your investments can be handled if you can't do it yourself. Document number 1, statutory durable power of attorney. Document number 2, medical power of attorney. It's the brother or sister to the statutory durable power of attorney. If I can't make medical decisions for myself, check me into the hospital, check me out of the hospital, authorize surgery, authorize medication, I'm giving you the power to do that for me. It's not the pull the plug document. We'll talk about that in a minute. It's just I give you the power to make those decisions where I can't make them myself. I've been in a car accident. I'm in a coma. I've had a stroke. I can't make those decisions for myself. This is the person who speaks for me. That's the second document. Third document, directive to physicians. That's the pull the plug document. I tell the world that if I am ever in a terminal condition, which means my doctor says I've got 6 months or less to live. That's my condition. If I'm ever in that condition, remove life support. Remove all extraneous measures. Or, case 2, my doctor says I am in an irreversible condition, which means I could live indefinitely on life support, but if the life support were removed, I would probably die. That's the Karen Ann Quinlan or the Terry Schiavo case, the vegetable cases. If I'm in either of those situations, I'm telling the world, remove the life support and let me die naturally. Very personal decision, but if that is your wish, you will help your family and your caregivers immensely by putting that down in writing ahead of time so they know what your wish will be. That's the third document. Fourth document, declaration of guardian. A guardianship is normally not needed if you've done these powers of attorney, because you've already said, here's who speaks for me. But if somebody comes into court and says, I want to be your guardian, and the court agrees that you need a guardian, and that person is appointed as your guardian, it trumps your powers of attorney. So if you had said, for example, I'm naming my spouse as my agent under my powers of attorney, and then my children in birth order, let's say, as the successors. And then the youngest child says, you know what, I can do a much better job of taking care of dad and taking care of dad's money than mom or my older siblings. And the youngest one goes into court and gets themselves appointed as a guardian. Guess what? They just jump to the head of the class. And they get to manage everything, and that wasn't your intention. So if you do a declaration of guardian, you say, I don't think I'll ever need a guardian, but if I do, here are the people that I want to serve and in what order. And you just mirror what you do with the powers of attorney. And then the last document, and I'll close on this, is called an appointment of an agent to control disposition of remains. Some people have either family circumstances or particular desires that they want to deal with in terms of disposing of their remains. I want to be cremated, I don't want to be cremated. I want to be buried in a particular place. I want my ashes scattered in a particular way. I want to have a particular kind of service. Whatever it is, you can do a document and it says, I'm designating you as the person who's going to have the power to do all this. This becomes particularly important in blended families where you've got fights between maybe surviving kids or surviving spouses. You know, what are we going to do with dad's bones? You know, this, that, and the other. And so if you're in a situation where that can be important, that document can be really important too. And I will close with this. If you do these documents, think about where you're going to keep them. What's a safe place to keep them? If you do one of these documents that gives all the instructions about what's supposed to happen to you, and you lock it up in a safe deposit box with all your other important papers, which will probably be opened about 2 weeks after the funeral is over. That didn't work out so well, did it? So think about where you're going to keep this, and think about who ought to have copies of your documents, because that can be really important. I appreciate your time today. If you have any questions, I'll stick around for a few minutes